legal issues in Georgia, including auto accidents, personal injury cases, and criminal defense law. Here is your host, Attorney Jason Carnell.
Hey folks, Attorney Jason Carnell here again. Today I want to talk a little bit about slip and fall cases, specifically liability, the liability portion of a slip and fall case. There are a lot of misconceptions out there about slip and fall cases among the general public. Most folks tend to believe that if you slip and fall on a foreign substance on the floor of your local grocery store, that they are automatically liable. If you injure yourself, they're responsible, they're liable, and unfortunately that's not true. You still have to prove negligence, and the first step in proving negligence in a slip and fall case is proving notice, that the store knew or should have known, okay, that they had actual notice or constructive notice. Actual notice is exactly what it sounds like. Someone from the store knew about the slipping hazard, or tripping hazard for that matter, and didn't do anything about it, or was in the act of doing something about it but didn't get around to it yet. Constructive notice has sort of been laid down by case law, whether or not a store has constructive notice. Basically, if the substance has been on the floor for 15 minutes or more, the store is deemed to have constructive notice. The time period can be less than that if you can prove that the store failed to abide by, or even have, for that matter, reasonable inspection procedures. But the important takeaway from this is that they actually had to know about it, either actual notice or constructive notice. And if they didn't have either actual notice or constructive notice, then they cannot be held liable. So what does this mean for you if you have slipped or tripped in a store and you've hurt yourself? Well, the first thing it means is that you need to report it. Okay, you absolutely need to report it. File a report with a manager or someone else, whoever is available to do that sort of thing. The reason for this is that is when that sort of triggers their duty to preserve video evidence from the area where the spill and the fall occurred, and the other video cameras in the store as well. Because there are a lot of different ways to prove actual notice. For example, one very important way is if a patron happens to create a hazard, one of your fellow patrons of the store happens to create the slipping hazard. A lot of times people do the right thing and they go and they tell someone about it. And maybe after receiving actual notice of the hazard, that store employee does the right thing, and maybe they don't. And in the event that they don't, that is an example of negligence. The fact that they received actual notice and they didn't do anything about it. But by notifying the store and by filing a report, again, that triggers the store's duty to preserve evidence. And if they don't preserve that evidence, they can be sanctioned during subsequent litigation with what's known as a spoliation charge. Okay, basically the court can instruct the jury that their failure to preserve evidence that could help you prove your case can be used against them, that there is a presumption that that evidence would have been harmful to them had they preserved it, and that's why the evidence wasn't preserved. So in short, folks, one of the most important things you can do is report your fall if you happen to slip and fall in a store. Remember that consultations are always free. You can call me at 770-322-4990, or you can visit my website at www.carnellfirm.com. Thanks, and I'll see you next time.
Thank you for tuning in for another episode. If you found this video helpful, please like and share it. If you have questions, remember, consultations are always free. Just call Attorney Jason Carnell at 770-322-4990. Or you can visit our website at www.carnellfirm.com.